Colleagues and friends, ladies and gentlemen, welcome to this webinar on the European Law Institute project on ecocide. Ecocide is a new word, a neologism, modeled on the word genocide that was first used at the end of the Second World War to characterize the crime consisting of a number of acts aiming at destroying a national, ethnic, racial, or religious group as such. In similar vein, the expression ecocide is the more and more employed to characterize conducts seriously harming the environment, causing to it long-term, even irreversible sometimes, damage. A conduct that may be attributed, of course, to states, individuals, legal persons, like corporations as well. Initiatives have been taken by states, by organizations, institutions, to criminalize such conducts and to affirm individual or corporate liability for them. However, the existing legal framework at the international, national, regional level is far from being satisfactory. This webinar, organized as a component of the annual European Law Institute Conference, will focus on the European Law Institute project on ecocide, which is intended to propose a uniform provision on ecocide as a crime to be incorporated in a legal instrument of the European Union, possibly a directive, in order to be adopted by member states. However, we will discuss it taking into account other important initiatives, particularly that aiming at amending the Rome Statute of the International Criminal Court by inserting in it the crime of ecocide as an international crime. And we will take into account also the steps that the European Parliament is discussing and proposes to adopt in order to improve the European Union legislation on the protection of environment. We have with us distinguished experts as panelists for a discussion on this complex topic. In particular, we have Robert Bray, who is a co-reporter with myself of the ELI Project and was former head of unit of the Secretariat of Legal Affairs of the Legal Affairs Committee at the European Parliament. We have Kate McIntosh, Executive Director of the Promise Institute for Human Rights in Los Angeles at the UCLA School of Law, and co-chair of the SENSE group that drafted the definition of ecocide. We have Jojo Mehta, who is co-founder of the organization Stop Ecocide, who promoted that initiative to draft a text of a provision to be inserted in the Rome Statute. And we have Marie Toussaint, who is a French environmental activist, member of the European Parliament. So with such a high-level panel, we are conducting the discussion now. I will give the floor first to Robert Bray to introduce and present the program, the project of the European Law Institute. Robert, you have the floor. First, I recommend all the speakers to keep within a reasonable frame time, because we have a limited time, of course, for the webinar, and we want to also to have the views of the public, of the participants in this webinar. Please, Robert, you have the floor.
Thank you, Fausto. I should first like to thank the European Law Institute and its staff for organizing this webinar, our distinguished panel, and last but not least, Professor Pocard and the other members of our project team. May I too congratulate the panel of independent experts on their work in drafting a new Article 8 ter for the Rome Statute. I would also pay tribute to the work of all those imbued with the sense of moral outrage so rightly invoked by Mark Allen Gray, who have labored to make ecocide an international crime. Above all, the late and greatly lamented Polly Higgins. My contribution will be in three parts, dealing with various aspects of the model rules which ELI's project team is considering. First, questions of criminal law raised by the project. Secondly, the civil law aspects. Thirdly, what I call Locus Standive for the natural world. And fourthly, the importance of action by the EU. So for the questions of criminal law, our aim is to produce model rules which could ultimately form the basis for an EU directive based on Article 83 of the Treaty on the Functioning of the European Union. At present, we're at the very beginning of the process. However, I can give you some idea of what we are founding our discussions on. But the issues raised, as Fausto already mentioned, are extremely complex and various. There is no time to address them all today. First, I would enter two caveats. It will not be possible simply to cut and paste Desan's panel's proposals. An addition to the Rome Statute is very different to a law which has to be applied in EU member states, and EU rules could be more ambitious than the proposed international crime and will have to be more detailed. A further consideration is that it is possible that the EU might respond to political pressure so as to create a crime of ecocide before the Rome Statute is amended, thus contributing to the development of customary international law and incentivizing the states party to act. The second caveat is that because of the difficulties experienced by some member states in considering that corporations can be the subject of criminal proceedings, we consider that the model rules will neither provide for corporate criminal liability nor preclude it. In drawing up the model rules, the question of what acts are to be regarded as criminal is critical. One approach is that of the Genocide Convention, which lists the acts that constitute genocide. The second is to define the acts constituting ecocide indirectly by referring to any act that causes a qualified damage. We will decide what approach to take after considering how environmental crimes are already dealt with in the member states, without their necessarily being qualified as ecocide. Probably the general thrust of national legislative practice goes in the second direction, because specific crimes are envisaged rather than a global crime on ecocide. The French law on climate and resilience takes a second approach insofar as it provides for amendments to existing legislation. We will then be considering when the offending act qualifies as ecocide. Under the French law, the act has to cause damage affecting health, flora or fauna, or the quality of the air, water, or the soil. Is this list sufficient to cover all the situations that may constitute ecocide, or do we need another definition? Do we need a more flexible one? What about outer space? Thirdly, how should the damage be characterized? Is it enough to refer to serious damage, or should the degree of seriousness be specified in order for the crime to be qualified as ecocide? Furthermore, should a specific minimum durability be established in terms of years in order for the damage to be able to constitute ecocide? Should a distinction be made between reversible and irreversible damage? Would such a distinction be useful? And if so, to what purpose? Then there is the question of the location of the damage, in particular transnational damage and damage in outer space. We will obviously be looking at mens rea requirements. Ecocide is a crime of consequences, where the perpetrators may be many and various. It has therefore been argued that ecocide should be a crime of strict liability, also because it would encourage preventive behavior and advance the polluter pays and precautionary principles. But we have to rule this out, as European legal systems do not look favorably on strict liability in criminal law. The civil law is perhaps another matter. Intent to commit the act is, of course, a necessary requirement. Some questions arise immediately. Should specific intent to cause damage to the environment as qualified be a necessary requirement for the crime of ecocide? This would be dol spécial in French. If specific intent is not required, should a lower form of mens rea be specified for the crime of ecocide? The French law does not appear to require specific intent, but requires awareness of the serious nature and durability of the damage, which could be inferred from the acts committed. In such case, however, should this be actual awareness, or could it be awareness that the alleged perpetrator should have inferred from the act and the consequence damage? This is what we call dol éventuel in French. Alternatively, should we take, instead of awareness, the criterion of foreseeability of damage to the environment? If so, should this be objective or subjective foreseeability? Then there is the question of jurisdiction. Should member states have universal criminal jurisdiction over the crime of ecocide? If not, should there be jurisdiction if the perpetrator is a national of the member state? Should there be jurisdiction if the criminal act is committed in the member state, irrespective of the place of damage? Should there be jurisdiction over the alleged perpetrators if the only link with the member state is the place of damage? This list of questions is by no means exhaustive. I'll now rapidly turn to the civil law aspects. Civil law has advantages in that civil proceedings can be readily brought against companies as compared with the difficulties of bringing criminal proceedings against legal persons in some jurisdictions. It also affords the possibility of injunctive relief to stop the damage before it occurs. Indeed, it may be thought that it ought to be possible to bring an application for an injunction in the civil courts in order to forestall planned activities which appear to constitute ecocide. Such an injunction should also be able to be brought against persons planning to finance activities in third countries and against persons importing products resulting from abuse of the environment constituting ecocide. In the field of criminal liability, the questions raised are, should civil liability depend on criminal responsibility, or should it be considered independently, irrespective of criminal liability being established? Would EU harmonized rules on jurisdiction be applicable to the civil liability arising out of ecocide? Do we need to amend Brussels 1 bis? Would they cover this issue exhaustively? If not, what additional rules would be necessary? Would existing EU harmonized conflict of laws be applicable and sufficient to deal with civil liability arising out of ecocide? Many consider that the emphasis should be placed as far as possible on restoration of the environment rather than solely on pecuniary compensation. Any limits on damages, in my view, should be reviewed. We should not replicate the situation in competition law where the fines imposed are not commensurate with the financial benefits of cartels. The project team will be drawing on ELI's forthcoming report on business and human rights, access to justice and effective remedies, and closely watching developments in the projects on environmental law and corporate criminal liability. I would like to finally briefly mention Locus Standive. This aspect is more of a horizontal one. That is to say, whether the European Public Prosecutor's Office could not be given responsibility for prosecuting the crime of ecocide, but also for taking up cases or intervening in civil proceedings on behalf of the natural world, the environment. According to the model law proposed by Higgins, ecocide as a crime is committed against inhabitants, which include indigenous occupants and/or settled communities of a territory, consisting of one or more of the following: humans, animals, fish, birds or insects, plant species, other living organisms. Could we imagine giving the EPPO the right to bring proceedings on behalf of inhabitants in this sense? It is worth considering. It took 50 years before the Rome Statute was adopted. We cannot afford to wait anymore. As Rachel Carson, the author of Silent Spring, put it so well so many years ago, man's attitude towards nature is totally, critically important, simply because we have now acquired a fateful power to alter and destroy nature. But man is part of nature, and his war against nature is inevitably a war against himself. What is happening to the environment and the ecosphere because of human activity is beyond alarming. People now rightly consider it their main concern. The EU is above all a community of values. It should support the efforts being made to change the Rome Statute and introduce the crime of ecocide onto the statute book, setting an example for the world. Thank you.
Thank you, Robert, for your presentation of the project. You have succeeded in a very short time to raise a number of issues that, of course, will have to be discussed, and we have to continue to discuss in conducting our project. I give the floor now to Kate McIntosh. Kate, you have the floor. You participated in as co-chair of the group that drafted the already mentioned text of a possible amendment of the Rome Statute. So please, you have the floor for your commentary.
Thank you so much, and thank you for the invitation to be here. And I must say, I found it really inspiring, Robert, to hear you talk about the project and the depth and substance and scope of the project that you are undertaking together with Professor Pokar. And I think it's just hugely encouraging to see that such a serious endeavor is underway that could have such a far-reaching impact. So thank you for that. That was very exciting. I think in the short time that I've been allotted now, I will just pull out some of the issues that we dealt with in our draft, that it would be interesting to hear, how you're thinking of approaching them in your draft. And we suggested some solutions which, as you've already pointed out, may not be transferable exactly to the European draft. As was pointed out, our draft was very specifically targeted to an amendment of the Rome Statute. So we're working within that legal framework, which is an obvious point of difference. We were, within that framework, inspired by, and we drew on as far as possible, existing law. And there I mean international criminal law primarily, of course, but also international humanitarian law and international environmental law. And we looked in particular at the one provision in the Rome Statute which currently protects the environment, which would be the war crime, which I'm sure everyone's aware of under Article 8(2)(b)(4). So having said that, a couple of points to pull out that I think were interesting and challenges for us, and I'll just talk about the way we solved them. So the first point to highlight, and I think the text of our draft has been put in the chat if participants want to look at it while I'm speaking. But the first point to highlight is that we crafted the crime as a crime of endangerment. So we didn't list enumerated acts, we didn't go down that route. We talked about material result, but it was a crime of endangerment rather than the actual manifestation of the result. In other words, the prohibited conduct is causing a risky situation. And we did that for a number of reasons, mainly because of the type of damage we're talking about. So if we want to, the kinds of things we can envision as ecocide and the complexity of environmental damage itself meant that waiting for the results to manifest or being sure that they would manifest, we felt would be ineffective in crafting the crime. And what we really wanted to prohibit or to deter was acts which could, which had a substantial likelihood of causing the kind of damage we're trying to avoid. And it seemed to us important to place the prohibition at that stage in order to deter ecocide. And we were inspired in that by some important precedents, and in particular, the precedent in Additional Protocol 1. So the two provisions within that Additional Protocol 1 to the Geneva Conventions, the two provisions which protect the environment, Articles 35 and 55, which prohibit employing means or methods of warfare which are intended or may be expected to cause widespread, long-term and severe damage to the environment. So crime of endangerment, I would love to hear your thoughts on whether that's something that might be possible within the ELI project draft, or otherwise how you envisage approaching that problem. The next point I wanted to pull out was how we chose to characterize the gravity, because obviously we're talking about an international crime for the Rome Statute. So it has to be a crime on the same level as crimes of genocide, crimes against humanity. So crimes which have lifted to a level of international concern. And you'll see from our draft that we characterize gravity by using the familiar terms widespread, long-term and severe. We did consider others, also from international criminal law. We thought about widespread and systematic, as in a widespread and systematic attack on a civilian population and crimes against humanity. But widespread, long-term or long-lasting and severe are the terms which appear in the existing war crime in the Rome Statute, in the Additional Protocol 1 articles which I referred to, and in the 1976 ENMOD Convention, of course, the convention prohibiting hostile modification of the environment. So we thought they're familiar terms, they have definitions already within international law applying to damage to the environment. It made sense to incorporate them. Then we had to look at whether to use those terms conjunctively or disjunctively. So the two precedents we have, the ENMOD Convention uses them disjunctively. So the prohibited damage is either widespread or long-term or severe. And at the other extreme, the additional protocols and the war crime in the Rome Statute is conjunctive. So the damage prohibited has to be severe and widespread and long-term. And as you'll see from our definition, we came down somewhere in between. The group felt quite strongly that severe was a must. It didn't make sense to have an international crime of causing harm to the environment, which could be anything less than severe. So in all cases, the damage would have to be severe. And then when we looked at widespread and long-term, we finally decided that the best option would be to have those in the alternative. So we had to have severe plus either widespread or long-term. Now, long-term, all of these terms are defined, or there's commentary about what these terms might mean, both in the commentary to the additional protocols and in the commentary provided by the Committee on Disarmament, and the commentary to the ENMOD Convention. So severe, we pretty much followed the definition of severe in the Committee on Disarmament, with just the addition of cultural resources, which we can talk about while we did that. But we pretty much followed the definition of severe. For long-term and widespread, we've expanded the definition. Long-term is defined by, for the ENMOD Convention, as either a few months or a season. And in the additional protocols commentary, it's defined in terms of decades. Now, we thought months and a season actually didn't seem long enough, and decades we thought was also problematic and might present issues of proof, for example. So we've defined long-term in terms which Robert referred to in his presentation. So we talk about damage which is irreversible or which cannot be redressed through natural recovery within a reasonable period of time. And we thought that was the significant framing for a crime, for an act to rise to the level of ecocide. However, we also understood that a lot of even very severe damage is redressed through natural recovery. And we didn't want to exclude massive, severe environmental damage, which could be redressed within a reasonable period of time. And that's why we made it in the alternative with the term widespread. And widespread Again, we modified the definition. Widespread is defined in the NMOD and additional protocol. Commentary is very much in terms of geographic area. So it's either hundreds or thousands of kilometers. We included the idea of extending beyond a limited geographic area. We imported the idea of transboundary harm as an important environmental law principle, which you also referred to. And then we were inspired by the definition of widespread in crimes against humanity. So we brought in the concept of widespread as grave impacts on human life, so large numbers of people being harmed by widespread. And here we had in mind, for example, an event which causes harm to humans in a concentrated urban centre. So the geographic spread would be limited, but we could call it widespread in terms of the scale of the number of people who are affected. And then we extended that to an entire ecosystem or species. So to take it out of the purely anthropocentric crimes against humanity definition. So that's how we characterize the gravity. You know, that I would be interested to hear whether that's an option that you're also considering looking at that term. I'm just checking my time. The last, I don't have much time left. So let me turn to the last very significant point, and that was our second qualifier. So as well as the gravity threshold, we introduced this idea of unlawful or wanton. And I think wanton in particular is an important point to raise. So those of us who didn't come from an environmental law background, you know, learned through this process that respect of the environment is not about, oh, there's my timer, is not about leaving the environment pristine. It is about living from and regenerating the environment, a concept which is enshrined in the principle of sustainable development. And we realized that in our normal human existence, we cause severe and both long-term and widespread damage to the environment all the time for purposes which we all agree are for the common good. And we could think about building, you know, much needed housing or communication links. We destroy the environment in ways which we think are reasonable all the time. And we thought very important to build that qualifier into our definition. And we've done this with the introduction of the term wanton, which we took from international humanitarian law. And we modified it somewhat to mean reckless disregard for damage, which would be clearly excessive in relation to the social and economic benefits anticipated. So really wasteful acts, damage to the environment, which cannot be justified as benefiting us as a human society, which is really done with reckless disregard for the damage. And we thought it was really important to have that qualifier in there. And I'd love to hear how the views on that and how you're thinking about approaching that within the European Law Institute. Thank you very much.
Kate, for your commentary. It is extremely interesting. I mean, the relations you pointed out on to international humanitarian law, in particular, certain provisions in the protocols that are important. And I like very much the first point you made on the risk, because this is extremely essential. I mean, Robert pointed it out on dealing with the possibility of injunctions. I mean, and in that sense, in the civil matter, but it's important that also the criminal be related to stopping actually a conduct which is ongoing. And I like, of course, the substantial likelihood standard, as you may imagine, Kate, because I think it was the first one to invent this standard in criminal, in a case, actually. Now let me give the floor to Geoffrey Mehta, and Geoffrey, you have the floor for your comments, equally important because you have a long experience in this matter, actually.
Thank you so much. And it's an honor to be here, and thank you to our kind hosts at the European Law Institute. I'm going to sort of open up the discussion a little bit broader to look at the wider context of this movement towards the criminalization of ecocide. And I want to start, like Robert, actually, by acknowledging my dear departed friend and colleague, Polly Higgins, because I know that many of us present came into this work one way or another through her inspiring crusade to have ecocide made an international crime. When she was diagnosed with terminal cancer 2.5 years ago, many people contacted us, both sad and shocked, and wondering what might happen to her work in her absence. Would it die with her? And as we all now know, quite the reverse has happened. It's funny. Sometimes when there is a strong figurehead for an initiative, others can be shy of coming forward. But when she passed away, people actually began to get in touch asking, how can we help make this happen? Now, the diplomatic work that Polly and our small team began from 2016 onwards actively supported the courageous stand that was taken by Vanuatu and the Maldives at the International Criminal Court's Assembly in 2019, just months after her death. This was a stand that brought the ecocide conversation squarely onto the international stage at state level, a position it hadn't occupied since Swedish Prime Minister Olof Palme's speech to the first UN Environment Conference in Stockholm in 1972. And the story since then has been an amazing one of connecting dots, as it became clear that there were other lawyers, politicians, civil society groups, many inspired by Polly, working towards the same goal. And 2 short years on, what started out as a grassroots campaign is now undeniably a growing global movement, with interest at government or parliamentary level publicly visible in 15 ICC member states, no less. Motions, white papers, parliamentary petitions, government statements, committee resolutions, and proposals of law have been issued in the following countries: Bangladesh, Brazil, Bolivia, Belgium, Canada, Chile, Finland, France, Luxembourg, the Maldives, Netherlands, Spain, Sweden, the UK, and Vanuatu, as well as Scotland, the European Parliament, the Nordic Council, and the Interparliamentary Union. France and Belgium are at the forefront, and Marie Toussaint, who's, I believe, just joining us, will no doubt be providing more information about developments there and in the EU itself. And more states are discussing it behind closed doors and simply haven't made this public yet. There is support from multiple organizations and public figures ranging from Pope Francis to UN Secretary General Antonio Guterres, and from activist Greta Thunberg to musician Paul McCartney. The recent climate protest movements, the school strikes, Extinction Rebellion, and others, have opened up a long overdue window of conversation in the media and politics, within which this call for mass destruction of nature, or ecocide, to be criminalized has finally begun to be heard. Indeed, the political appetite was such by last year that we were approached by Swedish parliamentarians with a request to draw up a legal definition of ecocide that could be seriously considered by states for proposal at the ICC. And that gave our charitable foundation the possibility of bringing together the independent expert panel, of which Kate McIntosh, who was just speaking, was the deputy co-chair, and whose definition she has just so eloquently presented. In turn, the emergence of that definition proved to be a hugely significant milestone. And with over 100 publications around the globe covering the story within a week, ecocide has overnight become a hot legal topic. Fortunately, Professor Picard and Robert Bray were already ahead of the game, with the European Law Institute having already put in considerable work examining the legislation for environmental crimes in the EU and preparing to build upon the definition of the independent expert panel in the EU context. And it's encouraging and wholly appropriate, I agree very much with Kate, that an institute of the pedigree and prestige of the European Law Institute is taking up this challenge, since, as we know from the recent very stark warnings of the latest IPCC report, the need for taking substantial action to curb the climate and ecological crisis is urgent and immediate. And the more that serious legal institutions and serious initiatives address ecocide, the more governments are sitting up and paying attention. Interestingly, while there has been some debate already in academic legal circles around the niceties of the definition from the independent expert panel, often it must be noted along the lines of not finding the definition strict enough, which we would contend fails possibly to comprehend the importance of the unlawful or wanton threshold that Kate was describing, both in the way that it future-proofs the definition and in the way that it gives it some dynamic flexibility. And it's notable that but it is notable nonetheless that such criticism has been conspicuously absent in the political world, where so far, at least, reception of the definition has been on balance quite positive. It seems that the drafting panel managed to hit a kind of a sweet spot which balances the need to protect from the most serious harms with the need to integrate with existing laws that may vary across jurisdictions. And that's where that second threshold becomes very important. Consequently, it appears to have landed well with diplomats and politicians, who, after all, are the ones who will be advancing a crime of ecocide at the ICC. Indeed, we believe it has probably added to what is already an emerging sense of inevitability around this law. We've been hearing from insurance executives and political advisors alike that a law such as this is expected, even if the exact timeframe isn't yet known. What we do know is that this conversation will, for example, be present at the COP26 climate talks in Glasgow in a few short weeks, because our organisation has been granted provisional observer status to enter the diplomatic zone, and we have been offered at least one official side event there. We have, of course, been focusing our work around the International Criminal Court, which currently only prosecutes individuals. This has been seen as a disadvantage by some who would like to see the prosecutability of corporations. And indeed, the ELI has said in its interim report that the project group will be examining the possibilities for this in the EU context, as Robert was pointing out earlier. We would, however, note that we see the individual criminal liability as a particular advantage in the context of deterrence, which is ultimately the whole point of putting ecocide law in place. While it is right and understandable that those who have suffered the consequences of ecocide will seek justice, the true aim of this law is surely to actually protect the planet by preventing destruction in the first place. And in that light, the potential for a specific individual to lose their freedom due to their act or failure to act is, we believe, where the true potency of the law lies. We were also really interested to see from the interim report that the ELI project intends to address such issues as restorative justice, which to the best of my knowledge has not hitherto been a part of the ICC's sentencing approach, but which I know Polly Higgins was deeply supportive of, not instead of, but alongside criminal penalties. It speaks to the rebalancing nature of what this law could achieve, which we believe goes well beyond the black letter of any given definition and actually starts to happen well before the law, or indeed laws, as is likely there will be regional and national variants, comes into force. So we believe, and this is something that Philippe Sands has also been at pains to point out on numerous occasions, that what this law has the potential to do, simply by being visible on the horizon, by approaching, if you will, is to change consciousness. It can start to create what we might call a healthy taboo around serious harm to nature. It can thus create a much needed safety rail for corporate activity, leveling the playing field for sustainable and eco-effective practices, such as regenerative farming, circular economy, renewable energy production, all of which already exist, but are simply not adequately supported by policy or investment, by preventing finance flowing to the old destructive ways. And this is hugely supportive of all corporate actors wishing to do the right thing. And we believe there are actually a great many of these. After all, we all know you can't ask a government for a permit to kill people for a new business venture. But at present, the same moral line isn't drawn around serious environmental harm. And it needs to be if humanity is to have a chance of thriving into the future. The very existence of a legal definition of ecocide makes this approaching future more concrete. And the more comprehensive the thinking around how the law will function, and indeed how it will be met with at the point of sentencing, the more that moral aspect will become clear in the public mind. So ultimately, while the project is very legally precise, the cultural and moral implications are truly transformative. And we believe, as Polly did, that this is a genuinely historic opportunity. We very much look forward to the progress of this project, and we're honoured that our foundation has been able to facilitate the first key step in the form of the international definition. Thank you very much.
For this presentation and for reminding us all the starting point, I mean, of all this exercise, and also you made some important specific points like restorative justice, which is extremely important in terms of environment, clearly. But also the idea that in any case, having legislation changes the minds of the people, which is what we have to do essentially to change the world. That's the only way. So thank you very much for this. Now we give the floor to Marie Toussaint. I already presented her before when she was not attending, and for giving her thoughts about what is being done in the European Parliament, especially to improve the legislation in Europe, and also at the domestic level, because you are active also in the changing of the French legislation on this point. Please, you have the floor, Marie.
Thank you, Fausto, and thank you, Robert and the ELI for this organization. Hello to Jojo and Kate as well. I'm sorry I need to go back and forth. This is the back of the year, and you know, we have many different events to launch at the same time. But I'm really happy to be here with you, and I'm also really happy of the work that you are currently doing, and we have a lot of hopes in what you will do. So why is that so important? I think that you already quoted a lot of reasons why this is important, and how we are moving forward as well, both in regarding the content with Kate and the support from countries and parliamentarians and public support with Jojo. But I want to say that it's really important that we meet here today, because we are at the beginning of a big international momentum for Ecocide, and the next 6 months will be really important. We need to really push during those 6 months, because we have a lot of events regarding international environmental law and also human rights law, and this is really the moment to grab the proposal of recognizing Ecocide and giving it the push that it really needs. So just to remind you that we have this September both the International Summit of the Conservationists of Nature, which is holding right now in Marseille and ending in this end of the week. Then we will have the General Assembly of the Human Rights Council and of the United Nations discussing, among others, the universal rights to a healthy environment, which is with a lot of links with Ecocide. In October, this will be the beginning of the COP on biodiversity. And of course, again, Ecocide is linked to biodiversity. In Glasgow in November, the COP26 on climate issue. And then at the GA, the next ICC General Assembly. I am a member of the European Parliament, and I just want to remind everyone that the EU represents more than 30% of the International Criminal Court. So even if the EU is not a voter in itself, it's the member states who are. If the member states and if there is a dynamic coming up from the European Union, then we already have 1/3 of the votes at the International Criminal Court level. So this is a real challenge to mobilize the European countries. And this is why, in this context, the work of the European Law Institute is so important with providing us with a European law that would be solid. I have to say as well that with the International Alliance of Parliamentarians for the Recognition of Ecocide that I launched last October, we had a discussion yesterday with the president, the chair of the Environmental Committee of the Bangladeshi Parliament, and he is also asking for help drafting his Ecocide law. So we see that we need to strengthen the links between activists, politicians who are drafting the law and lawyers who know all about that. And this is why also the work of the Stop Ecocide Foundation is so important. So why do we need this ecocide crime? I would say for both main reasons. First of all, because there is a situation regarding environmental crimes as they are already defined. According to Interpol, environmental criminality has become in just a few decades the world's fourth largest crime sector, growing way faster than the pace of the global economy. And it is now considered as lucrative as drug traffic. However, we don't see that as a political priority nowhere in the world. And Interpol estimates that looting and destruction of nature is now worth 110 to $280 billion a year. So this is absolutely huge. And we are destroying nature, and we are also giving a lot of cash to people whom we don't want to give cash through these environmental crimes, because Interpol estimates that 38% of illicit financial flows to armed groups involved in conflicts are coming from environmental crimes. And the second reason is, of course, that all crimes are not covered. And with the recognition of Ecocide, we are not only putting the focus on the need to fight against already defined environmental crime, but also to define and sanction other kinds of crimes. And in that regard, I want to say about EU law that we really need to overcome the current shortcomings of the EU environmental criminal law, because except from Italy as a country, we have nowhere in the EU, neither at the EU level or at member states level, the sanctioning of crimes that are not dependent on legislation. What I mean by that is that when you hurt the environment, well, you have a list of rules that you need to follow. And if you follow the rules, even if you hurt the environment, you have no responsibility for that. And this is what we need to change. When you hurt the environment, from now on, it must be considered as something to restrict, condemn, and then prevent as well. So what are the obstacles and challenges, and where do we stand? First of all, we needed a solid definition of ecocide to be able to, face with the opponents of this definition. So Kate presented the definition from the international panel, and this was absolutely essential to have that. And we have heard very few voices countering this definition, and we are now being listened to by people who were trying to tell us before that we were not serious. Now they don't dare saying that anymore. So this is a huge step in our work. And of course, the work of the ELI will be also really helpful and useful in that direction. We also talked yesterday with Virginius Sinkevicius, who is the Commissioner of the Environment for the European Union. And he is not able at all to tell us that this is not serious. So what is their argument now? Because before they could use this argument, but what are their arguments now? Well, what they tell us now is that we might need to recognize ecocide, but not yet. We have time. And what do we have time? Because we don't have enough public support. That's why they think. So just on France, well, we've been pushing for years for the recognition of ecocide with Valérie Cabanes and other lawyers. And we managed to get the French Citizen Convention on Climate to require the recognition of ecocide in the context of the fight against climate change. And the government and even the president used the word ecocide at different times, saying that he would push this on the international forum. But France didn't actually do anything yet in a diplomacy context. So we need to push France to take a stand on the General Assembly of the ICC in December. And inside of the French law, we required as well that the ecocide crime would be recognized. But they used the word ecocide to condemn attempts to the environment, damages to the environment that were almost all of it already covered, and they just increased the level of sanctions. So this is not ecocide. This is a good step to raise the sanctions, but this is not ecocide. And we now need to keep on mobilizing in France for the recognition of ecocide. And in that direction, what I want to say is that first, we have a very big presidential election year, which is everything in France. So this would be a moment to mobilize, but we will also have the French presidency of the European Union in the beginning of 2022, which leads me to what's happening at the European Union level. So the European Parliament, I didn't think that it would be so fast, but I actually managed to mobilize the European Parliament. In last January, we asked for the recognition of ecocide in order to be able to defend human rights and democracy in the world. Then we required to recognize ecocide to be able to fight against climate change and defend environmental defenders. Then on the strategy on biodiversity and on the strategy on environmental liability for companies. And this is also something that we need to dig into, because at the ICC level, we don't dig into the responsibility, the liability of companies, and we need to do that at EU level. What does the European Commission say? Was, as I told you, that this is not urgent enough. So what we need to do now is to mobilize a lot of people, both at national levels, but also at EU levels, because what's coming up is the revision of the Environmental Crime Directive, which will be on the table from December, mid-December onwards, which will be discussed during the French presidency, as I told you a bit before. And what we see now is that among the contributions to the public consultation, we had 40% of those contributions requesting the recognition of ecocide. So what we need to do now is to keep up the good work, both on the legal side with the ELI Institute and the members of the European Parliament that are committed to recognize ecocide, and also to keep on mobilizing the public. And this is a work that we do with the NGOs and the networks and the Stop Ecocide Foundation.
Thank you very much, Marie, for this intervention, which is very interesting also to know that some data that you gave, I mean, for instance, the position of Interpol on how this type of crimes is spreading around, and widespreading around, maybe not just spreading around, and how it's necessary to proceed quickly, actually, in our endeavors to reach some result. Now we have time for questions and answers, but I see in the chat, in the appropriate link, only two questions, actually one question, because it comes from the same participant, and it's essentially on the links between, it's very long, so I will not go through it, but it's on the links between the crime, ecocide, and the war crime on ecocide, which is not called ecocide, actually, that we have already in the Rome Statute, because there is a rule in Article 8 that I don't remember now the paragraph, but it's Article 8, in which some attacks to environment are considered as war crimes. So already at the international level of seriousness. I don't know whether maybe, Kate, you want to address this point specifically, or you certainly consider that the statute has already a provision on environmental crime.
Yeah, absolutely. There are a couple, I mean, thank you, Alfredo, for pointing out a couple of the other well, points of inspiration, I suppose you could say, of a couple of other elements that we drew from the international humanitarian law in crafting the crime, because Alfredo's also pointed out the proportionality. I talked about the wanton provision and how we try to include this balancing idea, which is inherent and runs through international environmental law of development, human development, economic and social activity, and protection of the environment. And although this is an idea that comes from international environmental law, we found the framework for it actually in the sort of proportionality requirements that appears throughout international humanitarian law. So we've put our sustainable development idea in international humanitarian law jacket, and Alfredo's pointed out here, for example, the prohibition of destruction of property, which is a prohibition which also uses the terms unlawful and wanton. So also talks about those two terms together as being, so the kind of destruction of property might not per se be prohibited, but it's prohibited when it's carried out either unlawfully and wantonly. And they're wanton again with this kind of reckless, this idea of waste. There's no need to do it. It was excessive. You know. And then brings in this proportionality element, not justified by, in this case, military necessity. And the same balancing, the same proportionality appears, of course, in the war crime that Judge/Professor Poker just referred to. So that's the Article 8 prohibition, which bans destruction of the environment, again, not justified by military advantage. So within international humanitarian law, we can have destruction balanced against military necessity or military advantage. And we've been inspired by that to craft this idea of balancing destruction of the environment with the kind of social good, which we all recognize that we will damage the environment in order to obtain a certain social good to a certain degree. So yeah, thank you for that question or comment and pointing out some more of those links.
Thank you, Kate, for this answer. I don't have any question or other question in the raised by participants in question and answer section, but perhaps I turn to the panelists. They may have questions to each other. I mean, so I don't know, Robert, do you have any reaction to the points that have been made by the other speakers, actually? Because this.
No, if I may say, I find it very, very helpful to hear Kate explain in such detail the proposed new definition and the background to it. I understand it much better now and appreciate it. I thought it was already good, but now I do understand it, and it's given us a lot of food for thought to work on. Now that we will start thinking about it, all these issues it's not easy. It's not easy. Also, the points that have been raised about deterrence and restorative justice are things that that all this is about. And we would really like to see the European Union get down to this. I've been a believer in the United States of Europe since the 1960s when I was a boy. And I still believe in it now, and the European Union as a force for good, and it should get its finger out and get on with it. That's what I think.
Thank you, Robert. Perhaps I may have a question myself to Kate. Why did you decide not to specify the acts, actually? The Genocide Convention specifies the acts, actually. You went in another direction, actually, not following that model. Was it to leave some space to the future interpretation, actually, by the ICC, and not restrict that interpretation as it is obliged to do with genocide, certainly, because it is not obliged, but that's a different issue. I don't want to go into that. It's too complex. It's too complex reasoning to say why the ICC go beyond the Convention on Genocide, but that's a different issue. So was that reason, or were there other reasons that it might be difficult to make the list, actually?
Yeah, we had a lot of conversation about it, and I think we could have gone either way at a certain point. I mean, there were some quite serious proposals about how we might enumerate acts, and of course it would always have been an open list, similar to crimes against humanity underlying acts with a other similar acts provision. But in the end, the consensus of the group was that there was a certain sort of elegance and appeal to just a short paragraph that just said what we were talking about. And even with an open list, I think there was a feeling that we might leave something out that should be in there, or, you know, we might influence the interpretation in a certain way and overlook something which, as you pointed out, either may become apparent, you know, the severity of the harm may become apparent that we're not aware of it now. So yeah, so in the end, I mean, I think it was not that we were completely against the alternative of the enumerated list. That was certainly considered, and quite some thought went into what that might be. But in the end, consensus was that the shorter one was maybe more elegant, maybe less sort of risky in terms of leaving things out, and potentially had a better chance of success.
Thank you, Kate. Now I have some questions rising from participants.
Jojo maybe wants to jump in.
Jojo, you want to add something?
I just wanted to add a brief thing there, actually. I mean, I agree with Kate and indeed with Professor Pekar about the potential kind of, you know, future applicability that works better without enumerated acts. But I also have noticed in conversation, you know, with the public and so on, that there's another aspect as well, which is that sometimes people, you know, will say to us, how can you put ecocide alongside genocide? You know, how can you say that ecocide is as bad as genocide? And I think that one of the things that is important to explain in that context is the difference between intent and consequence, because obviously with genocide you're looking at, you know, really quite a serious kind of evil intent, if you like, in terms of the intent to destroy people in whole or in part. And it's very difficult to argue that, you know, ecocide has that sort of, in a sense, that level of sort of evil aspect to it, because obviously ecocide tends to be committed en route to some other goal. However, when you look at the consequences of serious destruction of the environment, you can then see why it belongs at the level of an international crime, because the seriousness of the destruction of the environment is ultimately looking at a threat not just to a people in whole or in part, but potentially to, you know, human civilization as a whole. So I think, you know, sort of making that distinction really helps with explaining that, and it also and it's interesting in that light that the definition that the panel came up with does focus on consequences, or likely consequences rather than specific acts. So it's just an additional element in that conversation.
Thank you very much. I have other questions raised by participants. Now, Barbara Pozzo is asking whether our project, the ELI project, will have any relation with the Environmental Crime Directive, and we can take it together with another question. Thea Bonfour is asking if the ELI project is going to work on corporate accountability. Perhaps, Robert, you may take these two questions.
Well, as far as the Environmental Crime Directive is concerned, we all know there's being a review conducted of this. Fausto and myself actually had an interview with officials from the Commission, including from the Directorate General responsible for the environment. And we will obviously take on board the lessons that they pick up from the public consultation, which is going on at the moment. One at least of our members has taken part in the public consultation. But obviously, if there is a crime of ecocide, it's going to be a bigger thing. It's a single crime, whereas the environmental crime definition is about national offences against the environment and the necessity to prosecute them. The Environmental Crime Directive hasn't been a great success. And what we would like to learn from that, apart from anything else, is that any crime of ecocide has to be really effective. It has to have teeth, and it has to be really deterrent, which the Environmental Crime Directive sadly has not been. We hope it's improved. As far as corporate accountability is concerned, that is something that the ELI have been thinking about in another context, in the supply chain context, for instance. And the result of that, it seems to me, is that corporate accountability is very, very important. Corporate due diligence is important. But without having some sort of sanctions or civil remedies, these things are meaningless. You have good companies, as Jojo mentioned, that really want to comply and do the right thing, but you have others which do not. And that's why you need sanctions and civil remedies in addition to things like corporate accountability.
Thank you, Robert. I have now a question from Valeria Napoli. She puts the question, maybe it goes to Jojo and maybe also to Kate, if why it was not considered to create a new international court specifically for environmental issues, actually, including genocide, including ecocide, of course, but taking care also of other international environmental crimes that would not be of the same kind of ecocide, but perhaps a lower level, and why it was opted to amend try to amend the Rome Statute rather than going for a specific jurisdiction, in taking into account, probably, I imagine the question is motivated by that the issues to be dealt with in environmental crimes may be relatively different from the ones that are in the statute now, actually.
I'm happy to speak to that initially, at least. I think there's every reason to believe that in the future there may well be an international environmental court, and indeed potentially environmental courts nationally as well, in the sense that I think that the growing understanding of the importance of this area of crime is just at its beginnings. Obviously, as a campaign, as a movement, if you like, we've been aiming for the Rome Statute specifically, partly because it has a very precise amendment procedure, and it's a relatively simple, so to speak, way of approaching inserting criminal responsibility for environmental damage into an already existing statute, which it feels like a kind of almost a sort of potentially a bridging piece, where that can be introduced into international law, and perhaps over time this could also be become a direction in which an international environmental court, for example, could come into play. But that's a far more massive project. And when one starts from the beginning in terms of creating a new treaty, which would be required for something like that, that can be many, many, many years in the making. And we don't believe we have the luxury of that many years to get this issue addressed.
That answer. Indeed, there are other institutions that have gone in a slightly different direction. For instance, the Permanent Court of Arbitration in The Hague has a special regulation concerning environmental arbitrations, and recently has also a special regulation, a new special regulation on outer space disputes. So that might also include environmental disputes, but they have two different panels, actually, two different types, because of the expertise that may be needed to deal with these matters. But this may be for the future, so it's also a possibility. I have other questions. Well, Ilaria Pretelli is asking something about the mens rea, and as to how the one can reconcile the approaches, I think, that has been taken in the proposal of the panel on definition of ecocide, with the general approach of the Rome Statute, actually.
Yes, I can answer that. Thank you. I was going to mention mens rea, but I overdid my 10 minutes. So,
of course.
so that's I'm very happy that with that question, we can come back to it. So the mens rea that we had put, of course, as I've mentioned, are acts, these unlawful or wanton acts committed with knowledge of the substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. So we're back to so knowledge of substantial likelihood. Now, as I'm sure everyone is aware, the Rome Statute has its own default mens rea in Article 30 of the statute, where it defines the mens rea, the default mens rea, both with respect to conduct and with respect to consequences. So with respect to conduct, there has to be intent to commit the acts. And with respect to consequences, the requirement is either intent or knowledge that the consequences will occur in the ordinary course of events. Now, at first blush, that might seem to fit quite well with Ecocide. So there's intent to commit the particular act, whether it's, you know, cutting down trees or emitting carbon dioxide. And with respect to the consequences, the damage to the environment, there's knowledge that it will occur in the ordinary course of events. So as we've said already in this session, nobody, and most people in any case, don't actually intend to harm the environment. They carry out certain intentional acts which then do harm the environment. However, the jurisprudence of the International Criminal Court has interpreted that standard extremely highly. So the acts have to be there has to be a virtual certainty that those acts will occur. And we thought that that was not feasible for the complexity of environmental harm. So we could think of too many situations where the environmental damage that would result from the acts could not be said to be a virtual certainty, whereas we thought it could be said to be a substantial likelihood. So Article 30 provides the default, but it also provides that another mens rea can be substituted. So it says unless otherwise provided. So we have provided otherwise in ours, and it's not the only element of the Rome Statute which has provided otherwise. So we've included the idea that the mens rea is knowledge of a substantial likelihood of the severe and either widespread or long-term damage being harmed, which we thought was stringent enough to only catch serious criminal behaviour, which should be brought before the International Criminal Court, but also broad enough, let's say, to encompass this harm with its very complex, causation, which couldn't be said, at least at the current state of knowledge, to always be of virtual certainty at the time of the commission of the acts.
This standard is very close to dolo eventualis, of course. That's one of the problems, I mean, in international criminal law, which is, but it's very important actually. The last question we have we are closing, but because the last time for a very last question from Rita Giannini, who would, I don't know whether Robert, you have seen it in the chat. Would know more about the civil aspects of including how to enforce a decision, a monetary decision taken in country A. Rita mentions the UK, but in country A for damage created in another country actually, and how to proceed. Now, the UK maybe has been mentioned because now implementing decision rendered in the UK is very difficult outside, but or more difficult outside than it was before. But if you can give a short point, Robert, because we don't have time to go beyond.
Thank you, Pastor. Yes, Rita, I do agree that the possibility of the civil proceedings are useful because the burden of proof is low. It's just a balance of probabilities. Yes. And you can act faster as well. You can go out and get an injunction, all this sort of thing. As far as enforcing judgments are concerned, of course, we in the European Union have this marvelous instrument called Brussels 1 bis regulation now, the recast. And I'm very sorry to say that the UK has failed in its application to join back up with the Lugano Convention, which is a great shame. One might think that the Commission has been perhaps a little harsh on the UK, but I don't think so, really. I think that a country that cannot be trusted to keep its own promises made in international conventions can hardly be trusted to enforce judgments abroad, even despite the fact that the British judiciary is the best in the world. But the answer is, of course, that judgments from European countries can or will be able to be enforced in the future Judgments Convention and under existing reciprocal conventions that exist between individual EU countries and the UK. Where no convention exists, of course, you have to rely on the common law to have a judgment enforced. And under the common law, if I remember rightly, you can enforce a foreign judgment as if it was an ordinary judgment for a debt. So there are solutions to these problems. The solutions to the UK's problem is to pull itself together and rejoin the EU, but that's another question. Thank you. Sorry to be facetious.
Thank you, Robert. This concludes our panel discussion. Actually, I'm very happy. It was a lively discussion with good presentations and to the point, and some questions, good questions, have been raised by the participants. Of course, it's not a discussion that closes now in this webinar. Is not closed outside the webinar. Is not closed in the group that is carrying out the project in the European Law Institute, because it will benefit also of this discussion in continuing our work and trying to get to a good proposal that would, but what is clear is that we need certainly a provision on the international crime as the one that has been proposed by the SANS group, but we need also some domestic legislation in states which complements that, because it's clear an international crime has to keep a certain level of criminality, let's say in quotes, but a seriousness. But there are other crimes that are maybe a lower level that would not reach the international scene, but that are equally important to arrive to a solution to protect the environment. So I close because the time is expiring, and I thank warmly all the panelists for their contribution to this debate that we hope to continue again in other fora, of course, but or even in ELI in the future, in future activities, in future meetings. And I thank the ELI again for having accepted to organize this panel during the annual conference, and the Secretariat for all the efforts made in having this succeed. Without a good Secretariat, these events normally do not succeed well. So thank you very much, and see you on other opportunities. All the best.
Thank you so much.
Thank you.
Thanks to everybody.